And I appreciate, obviously, Mr. Jamison being here and Mr. Cooper as well. And I had asked to have this meeting today to just have any questions that folks in the council may have. Hopefully you can get those answered. I've heard, quite a bit about the fact that it's confusing, and it can be confusing, and so I just wanted to have an additional opportunity to have some bright minds here in the room and to ask your questions. Obviously, there's just a recap, basically, is that right now we're talking about expansion of landfills and we're talking about new landfills. And if there's an expansion of a landfill currently, it would go before the Regional Solid Waste Board, and then it would go on to the state. And then if there was a request for a new landfill, it would go before the council via resolution, and then from there to the Board of Zoning Appeals. And under the Jackson law, both processes would be an ordinance process, and it would go through 3 readings. There would be incredibly robust notice provisions, such as, there has to be notification sent out within a 3-mile radius. There also has to be signs that are 5 by 3 feet that list what's going to be placed in the landfill, what kind of a landfill is it, and as to where you can go to get additional information about what's going to be in the landfill. There are a few things I would like to point out that do make this something I think is very strong and positive for Nashville. Right now, if there's a new application for a permit filed at the state can continue to work on that permit right now without worrying about what the council does or the local body does. However, if you have the Jackson law, the state's got to wait on us. The state cannot begin working on a new landfill permit until we've weighed in. Additionally, in a lot of these issues, we do have our Regional Solid Waste Board, but I will say that the commissioner of the Tennessee Department of Environment and Conservation is not bound by anything that the Regional Solid Waste Board does. However, if we have the Jackson law, they would be bound by that. Another issue is that it covers us 1 mile into other counties, which is something that there's no way that we could possibly do that right now without the help of, without the Jackson law. There's just no way to do it. And the other thing is that the council, in this particular situation, when we're determining landfills, the Jackson law has a list of things the council must consider, and that would be, the impacts, road damage, location compatibility, the health and health effects from the proposed waste streams and the like. So we are considering things that are going to improve the quality of Davidson County as well as potentially in the entire region. And so without the Jackson law, we don't have those considerations. We don't have a chance to weigh in on that. So I think it gives, in the end of the day, I think it gives each district council person more of a say-so on these kinds of issues. And I think it's an important issue. And again, when you have more regulation on landfills and the like, what that does is it encourages, in my opinion, it encourages more of a change in the industry to where people go more to recycling and composting, because if they don't change the way that they're doing these things, obviously competition is going to come into into the industry, and they might not be around. So we're not saying that they can't expand. We're not saying that there can't be a new landfill. We're just saying that the council would like to weigh in on that, and there's a lot of pros and cons, but that's enough of me talking. Like I said, I do have Mr. Cooper here, the Director of Metropolitan Legal, Mr. Jamison, and then there's another gentleman in the back, Mr. Brian Paddock, who is a former legal chair of the Sierra Club, and we actually were just trying a case today against TDEC. And he just happens to be in town. Elizabeth Murphy could not make it tonight. She got called away at the last minute, and so, and I apologize for that. But at this point, I'd like for you guys to just make sure that you can get as much information as you possibly can so that you can make an informed decision and where you stand, because a decision is only good as the information upon which it's based. And so tonight is kind of a fact-finding mission for those of you that have questions. And so at this time, I'd like to turn it over to anyone who'd like to ask questions of Mr. Jamison or of Mr. Cooper.
Councilmember Johnson, you're first, and then Councilmember Murphy, you'll be next.
Thank you, Chair. I think one thing I would like to make crystal clear is definition of landfill. Because you said landfill will go to Board of Zoning, and we do have ability to decide the location, which is applied only to sanitary landfill. Because C&D landfill, it is strictly a special exception. It goes to BZA. it does not even involve the council. So I don't know why it was left out of 174280. So that particular section does not address C&D landfill. And the last landfill application we had was C&D landfill in District 22. That was the last application. So it did not even involve council because it was zoning was AR2A, so landfill was allowed under the land use policy under special exception. So that means is, if anybody has concern, it has only 15 minutes, aggregate 15 minutes with everybody. So that's the only chance for the regular citizen to address any and every concern. And also because it's a BZA matter, so Board of Zoning Appeal, they do not even consider impact or property value or whatever the concern Jackson law will allow you or us to consider. Instead, all they have to consider is setback, access, landscaping, hours of operation, and so forth, only specified in special exception language. I think that's a big difference. You know, while a Jackson law will allow us to consider all the environmental concern, and it has 3 readings, but C&D landfill have only 15 minutes with the Board of Zoning Appeal. So just wanted to make that point.
Councilmember Murphy.
Thank you. I just wanted to share that spread on the member's desk is a lovely state of Tennessee map that I personally colored in for each and every one of you. They were photocopied, so. But I realized that I left off that the bottom part, it says counties with, and then there's a space, and there was supposed to be an asterisk drawn in there, and I missed that. So I apologize, and I guess give me a C- on that. I also shared a blog post that it talks about the Camden landfill, but it has an interesting story about former Representative Doug Jackson and his experience when he passed this that I thought y'all might enjoy. It's what I quoted from last time we had a working session. I spoke in support of this last time. I'm speaking in support of it again today, and I, again, think it's kind of interesting that we still have not received great opposition to this legislation. And it's because if you are a good actor, you wouldn't be against this legislation. It gives our people more of a voice. It gives us more of a voice. And I think it's time that we take the responsibility and step up and actually take local control that the legislature is giving us. So thank you.
Councilmember Rosenberg and then Councilmember Pulley.
Thank you. A few questions. First of all, the eight magic rules or whatever that go along with the Jackson law that a court would be considering on appeal. Is it the case? My first thought was, okay, well, if any one of these 8 things can be argued, then they'll uphold the council, and everything falls under taking care of the neighborhood. So that didn't make sense. But I guess my question is do they look for any one of those 8 things to be true in order to uphold the council, or do they consider all those 8 factors in their totality and make a decision based on the balance of those 8 things?
The statute that specifies the 8 criteria, it says the following criteria shall be considered, and it lists all 8, and before the 8th is the word "and." So that would indicate that all 8 should be considered.
So even if we have an extremely compelling case on one, if they think that 3 others lean in the other direction, that would be enough to possibly consider overturning it?
You mean if the council denied it?
Correct.
Based on one of the conditions?
Based on one of the conditions, but they found that the other 7 were leaning in the other direction.
I mean, there's no provision in there for weighting of the conditions. I mean, theoretically, the court could determine that in the judge's mind that the balance outweighs the other direction and overturn it. I mean, that's.
Okay, so it's
That is
not
a
that if
possibility.
any one of these 8 conditions are met, it's enough to uphold the council's denial. They look at more than that. It's not, okay, you met one of these 8 criteria, so we're not going to look at the
The
rest.
court is not limited to looking at anything. You know, since it is de novo, so the court can look at whatever evidence the court wants. The court can ask the parties to go through discovery process and look at whatever evidence is gleaned from that.
Okay, and then also I've heard reference to the chancellor and to TDEC and all that. Where do appeals go now? Where could appeals end up now? And where do they go? And where could they start and end under the Jackson Law with which entity?
Which type of facility are you talking about?
Does it? What do you mean?
It makes a difference.
Between C&D and solid waste, you mean?
Yeah, between C&D and a sanitary landfill.
Both.
Okay, so if it is a sanitary landfill, once the codes department or BZA gets an application for a special exception, they would contact the council office. And the council would have, is it 60 days between the time of being notified and would have a 60-day period to vote on whether that is an appropriate site. If the council denies the site, it does not go to the BZA. The applicant has the ability to appeal the decision of the council to Chancery Court. And since the council is essentially acting as the BZA, it is a writ of cert review. It goes up as a writ of cert to Chancery, and then the chancellor will review the record that the council considered in making its decision. And if the court determines that there was any reasonable basis for the council's action, it will be upheld. If the council doesn't think that there was a reasonable basis, they can overturn the council, at which point it would go to the BZA. If it is a C&D landfill, that is a special exception in the agricultural districts, but there's no council review. It's just BZA review, as Councilmember Johnson mentioned. If it is in a commercial or industrial area, it's permitted with conditions. And as long as you meet the conditions, you're granted a permit by right. So there's no BZA review and no council review. It's just a straight permit.
And under the Jackson Law?
Under the Jackson Law, all of those or both of those types of facilities would come to the council first before going to anyone. If the council looks at these 8 factors and determines that this is not an appropriate location, the council can turn it down. The applicant would then have the ability to appeal that decision to Chancery Court, who would essentially step into the shoes of the council and make the decision all over again.
Okay, does TDEC play any, I feel like Councilman Leonardo's mentioned TDEC as part of either some scenario.
With the Jackson Law, TDEC comes into play after the council consideration. With the other landfills, I think, is it after the BZA that it goes to the Solid Waste Region Board? Yeah, so if it is a special exception for a sanitary landfill or a C&D landfill in agricultural district, it would go to the Solid Waste Region Board after BZA consideration. And then the TDEC director on an arbitrary or capricious standard could overturn the Solid Waste Region Board.
Okay, that's under Jackson.
That's under the law as it exists right now. Under the Jackson Law, if the council turns down any of those facilities, it never goes to TDEC.
Gotcha. And then one last question. Council Lady Johnson mentioned that 174280 does not include C&D. If we don't pass the Jackson Law, would we have the option of adding C&D to that that code?
This has been the most vexing issue, I would say, for the council is what are the options if the Jackson Law doesn't pass? So there are three scenarios I want to go through with you. It is, I think, the considered opinion of council office and Metro Legal that the Jackson Law would preempt any landfill-specific zoning mechanism that we have in the zoning ordinance if the Jackson Law were to pass. That stemmed, you may have heard me talking before, from a 1995 paragraph that used to be in the Jackson Law that said it's not our intent to preempt any local zoning ordinance. They removed that in 95, so the presumption is it's their intent to occupy this field of landfill regulation. Then council asked, well, can we add to the zoning code? If we don't adopt the Jackson Law, can we add to that? We can add provisions in the zoning code, but we can't add anything that specifically addresses landfills because it's clearly the state legislature's intent to occupy that field. We already have the provision in 174280 that talks about you have to have a resolution before a sanitary landfill. That might suggest to you that we can do more of that. And we probably can, but it's a matter of degree. And if the state or a chancery court considers what we're doing to be invading the province of the state legislature, regulating landfill specifically, we can't do that. Right, and that's our problem on a lot of this. We don't have the typical appellate case decision on these specific points. So we're putting together appellate decisions that address it parenthetically, attorney general opinions, and giving you what is the most likely episode or outcome. Lastly, could we eliminate the special exception and create a new zoning provision or classification specifically for landfills? The answer is probably, but not, we don't have absolute certainty to that. And that, again, is because there's not a specific Court of Appeals appellate decision telling us one way or the other.
Okay, great. So is the reason that if 174280 does, for whatever reason, address sanitary landfills, we can't add C and D because that'll be too specific, or just because we'll be stirring up a bee's nest we don't want to get near?
It's just a matter of degree, and I can't tell you if you've crossed that line once you add C and D landfills. Is it worth an effort? Yes. How would we know on the council floor? We wouldn't until we get sued and a court determines that you've stepped into the province of the state legislature's attempt to preempt landfills.
Fantastic. Thank you.
You're welcome.
I appreciate it.
Councilmember Pulley.
Thank you, and forgive me if I'm late to the party on some of these very, very basic questions, but see if this really sums up what we're talking about here. Basically, in its simplest form, this law will give the council the opportunity to go through 3 readings every time one of these comes before us. Is that accurate? All right. So right now, under the existing law, that doesn't happen. I heard Nick say that if it's expansion, you got one set of rules. If it's new, you got another set of rules. But this simplifies it, gives the council an opportunity to weigh in on it. And we can't really arbitrarily weigh in on it because we've got to weigh in based on these 8 things that are in the law. And if we do this arbitrarily and don't consider those, we're going to get defeated in court anyway, right? So this seems pretty simple to me, that this, in a nutshell, gives us the opportunity to weigh in on these things as they go forward. Now, I think you might have addressed this, but maybe because I was paying half attention to your answer, maybe you could go through this again. But given the preemptive nature of this legislature, are we at risk of them doing something to kick this down the curb like they've done before? Or is that what Council Lady Murphy's blue thing is there to tell us?
Based on recent trends in the Tennessee General Assembly, if the council turned down a landfill, it would not surprise me at all if a bill was filed the next session that took away your authority to regulate them through zoning. I mean, that's just the way they did it with gas compressor stations just this year. Right, so that Mike pointed out, there are 44 counties in the state that have adopted the Jackson Law, but that still would not prevent them from targeting Metro as they are wont to do.
Yeah, as they've done frequently, and probably will continue to do. But based on what I just heard you say, it appears as though if we arbitrarily turn one down, that may spur them into action, whereas if we're responsible with this law, maybe they'll leave us alone. Is that kind of where you're headed with it? What do you think, Nick? All right. I guess I'll leave it at that for now until I can figure out something later to ask you.
Councilmember Cooper.
Thank you. A couple of quick questions for our legal team. How unpredictable are judges on matters like this? I mean, there's not that much, because there's no appellate history particularly, this is all to be invented, right?
All I know is what has happened here. I have not followed other landfill or waste use issues in other counties. Since I have been here, there have been 3 that have been challenged. They were not landfills. One of them may have been a C&D landfill, but at least 2 of them were waste transfer stations, which doesn't fall under the Jackson Law anyway. But the courts on 2 of those instances, and this was an arbitrary and capricious standard giving great deference to the council, on 2 of those occasions, the court determined that, yes, the council had a reasonable basis for making that decision to deny it. Everything's fine. The third one, the Chancery Court said the council's action was okay, but the Court of Appeals said that the council did not build enough of a record other than people in the area not wanting the facility, and said that that was not enough. The Court of Appeals overturned the council, but the applicant by that point had dropped plans and sold the property.
And then would one of the advantages of the Jackson Law be that it helps assemble the record? Because it's clear on the 8 grounds, so that every hearing that you had on it would inherently have to address the 8 grounds.
That's correct. Yeah, I mean, the specific 8 grounds are not included in our zoning code. I think the zoning code just says you look at the appropriateness of the site, and theoretically the council should consider whatever factors the BZA would consider, but
inherently you're assembling a record with which your appellate lawyer would like to go to court with.
That's correct.
Do we have any other questions from council members? Councilmember Rosenberg.
So under our current law, there's the reasonable chance that if we turn down a landfill, the legislature will, swat at us and act like, never mind. It's also just as likely, I guess, that if we pass the Jackson Law, they could say it doesn't apply to a metro form of government between so-and-so. So should we just turn off the lights and forget about this whole thing?
The only reason I would be encouraged that the state legislature might not act is that if we do, in fact, arbitrarily turn down an otherwise qualified landfill, they have pretty effective and immediate relief in the Chancery Court and wouldn't need to change the legislation. But I hear you in terms of what the state legislature has been doing recently.
That gets you, Councilmember Rosenberg? Councilmember Pulley? Councilmember Johnson?
Thank you. I would like to share a couple of things because, once I discover our current Metro Code does not include C&D landfill, so that is special exception. And 5 years ago, C&D landfill in Bellevue was considered. And back then, because we do not approve C&D landfill or any other facility landfill, so frequently, so that's a new process. So the applicant went to Solid Waste Regional Board first. At the same time, they applied to the TDEC, Solid Waste Regional Board and TDEC, they applied at the same time. Because TDEC is the final authority to give the application to applicant. So anyway, so that should not, I think the misconception, some email we received is Solid Waste Regional Board will have authority to consider environmental effect or neighborly thing or whatever required in Jackson law. It's not true. A Solid Waste Regional Board's duty is to determine if the C&D landfill is within the 10-year plan or not. If the 10-year plan for our county, Davidson County, requires additional C&D landfill to be installed, or if it was in plan, they are obligated to approve new C&D landfill. And so Board of BZA, technically BZA should approve or disapprove the location, specific location, based on the setback and so forth, based on special exception. But 5 years ago, because we did not have that kind of process, it did not work the way it's supposed to work. But since then, we have changed the process. So now, if anybody will come to apply for the C&D landfill, the way I understand is they have changed the process, so they will come to BZA first. And only when it was approved by BZA, it will advance to Solid Waste Regional Board. Otherwise, it will not go to Solid Waste Regional Board.
Councilmember Rosenberg, your light's on. Do you have a question or comment again? Okay. Councilmember Cooper? Any other questions at the moment? Otherwise, we'll turn it on Mr. Paddock's microphone to address us.
Thank you, Mr. Chair. As chairman of the legal committee for the Sierra Club Tennessee chapter over many years, I watched a number of places adopt the Jackson law or apply the law they had already adopted. And I'd like, and I sometimes actually have taught the Jackson law in environmental law classes and gatherings. Let me clarify a couple of things that have come up from my point of view. Of course, you should always rely on your own counsel, not me. First of all, Councilman Leonardo's statement about expansions and so forth. The Jackson law only operates prospectively. If Metro adopts it, then it will apply to any future proposals for landfills. But it cannot apply to any existing landfill or any proposed expansion of an existing landfill. So that's the difference between, for example, an expansion or something that's already here that people may not like and may not want to see get taller or wider, but the Jackson law cannot help with that. But it does give your community control over future proposals. The second, there's been quite a bit of discussion about C&D landfills, construction and demolition. Just to remind folks, the state regulation for that, what is now called a Class 3 landfill, is that it requires only a liner made of highly compacted, somewhat impermeable clay. It does not have a plastic liner. It does not have a leachate collection, so any rainwater that washes through whatever's in it is not collected and subject to analysis and treatment to neutralize pollutants that may have washed out of whatever's in there. Difficulty on the ground with C&D landfills is that they often have poor or no supervision of what goes into them. And it's supposed to be, you know, tree trimmings and things like that, but because it's demolition waste and construction waste, people throw in barrels of leftover materials, solvents, paints, and so forth. And we've had a few cases where there have been toxic materials, and because there's no leachate collection, if those containers rust or are defective and release, why, there's really no way to deal with that. That's going to get to the clay liner, and then you put all your money on one liner. And that's simply the standard for approval by TDEC, is that engineering that's no impermeable plastic liner, only clay, and no leachate collection. And I think C&D landfills, particularly as we continue to grow, present a real challenge to our management. By the way, the Jackson Law basically says a landfill is any proposal to put stuff in the ground. Not a basement, not a slab, but any kind of material that you're trying to discard. It's a very broad functional description. And the other thing that I think is background to all this consideration is that landfills are forever. The permits do not have a period of years. The permits are set up for a number of years in which material can be received, and then you have to have a closure plan which is approved, and you have to have, in some cases, financial security to assure the proper covering and deflection of additional stormwater, ongoing collection of leachate unless the cover is so tight that you can be assured that there's not going to be any leachate. And I think that's always been the problem that has confronted the United States as a country that under federal law has done more to recognize the problem of solid waste. And in Tennessee, of course, we recognize it because we find it along the edges of our roads, at least some of us in rural areas do. But we've never really solved the problem of the fact that landfills really are forever. The other thing that comes up in landfills that has not been mentioned here is a thing called special wastes, and that's the teaching example of what's happened in Camden. And a Class 1 or Class 2 landfill, Class 1 is considered what I think we're talking about as a sanitary landfill, which is basically garbage from the activities of residents in an urban area. But a Class 2 is sort of the same thing and to virtually identical engineering requirements that is designed to handle materials that come out of waste products, that are waste products from manufacturing operations. Those are not necessarily kept strictly separate, but there are two different permits. But once a landfill is operating under either a Class 1 or Class 2 permit, it can apply to take what are called special wastes. And special wastes are, by definition, things that are bulky and nasty. Special wastes include things like medical waste, coal ash, radioactive waste in some cases. There are a few. You may have recalled the situation where the landfill near Murfreesboro a few years ago was discovered by Channel 4 to have having had permission to accept radioactive waste, and people rose up and raised Cain, and the operator finally decided not to take it anymore, even though the permission to take it is still legally in existence. So the original list of what's going to go in a landfill, which is fairly horrifying, at least I think ideas of where you throw dead animals are horrifying, but that's not fixed in time. And on a special waste, what the operator does, and they do this usually at the behest of someone who has special waste they want to dispose of, is they send TDEC a letter and a form, and they say, we'd like to start taking radioactive waste, we'd like to start taking coal ash, we would like to start taking aluminum dross, which is the cast-offs from the process of recycling aluminum, and which has those terrible properties of generating ammonia when it hits air and water, which is the problem, one of the problems in Camden. So that process is not secret, but it is completely invisible. There is no notice given to the public. There is no notice given to the neighbors of the landfill. There is no notice given to local government. And so you can have what you thought was a perfectly, not perfectly, but an acceptable landfill operating as a Class 1 or Class 2 landfill, and all of a sudden it becomes a landfill that's taking some kind of a special waste and has a lot more traffic in and out of it and a lot more impacts on the adjacent area. The 8 criteria have been mentioned, and what happens afterwards in a court. I have found that the public hearings, and particularly people who really want to have their say-so about the landfill, obviously you've been in a lot of public hearings, and you get a lot of people that just say, we don't want it. But there are usually, in my experience, a group of people who say, okay, there's these 8 things that we can talk about and that we should talk about, and they go out and they bring in the numbers on traffic impacts, on accidents in the area, on the issues of impacts on property law, on property values. I've seen a number of these where actually people who make their money buying and selling real estate or are involved in those transactions, realtors, come in and give quite persuasive testimony of their experience of what happens in a community that it winds up being adjacent to a landfill. So there is an available hard evidence on each of those criteria. Thank you.
Mr. Jameson?
Thank you. I appreciated all of that insight, and it was interesting. I did want to comment on the concern that the Jackson Law is a prospective-only act and would not apply to expansions. I know this has been a topic of some confusion in terms of what facilities to which the Jackson Law does and does not apply. The council office contacted Joe Sanders, who's the chief legal advisor for TDEC, and he stated in writing and on the phone emphatically that the Jackson Law applies both to existing landfills and to expanding landfills, regardless if they were previously permitted or are new, laterally expanding. Not to vertically expanding, but then neither does the current provision. Our law director, Mr. Cooper, then reminded me that appellate decision, Wheatley versus Martineau, reaches precisely the same conclusion, that the Jackson Law does in fact apply to laterally expanding landfills, even for pre-existing landfills. I just wanted to make that comment.
Councilmember Murphy, did you have a question?
I did, but I've got to go, and I think Mr. Jameson just covered it. I wanted to clarify that even like the current landfills that we have in Davidson County, if we pass this tomorrow and they wanted to expand in October, as long as it wasn't vertical, we cover it. Jackson Law covers if they wanted to do 5 feet or 50 feet wider, just not the vertical part. I thought I had just clarification. All right, thank you all for having this, and see y'all next week.
Thank you. Councilmember Leonardo?
Yeah, I'd like to thank everybody again for being here. And are there any other questions before we adjourn? Okay, well, I'd like to thank Mr. Cooper for being here. And Ms. Ladd, I'm sorry I didn't acknowledge you to begin with, from Metro Legal, as well as Mr. Jameson. And I would encourage you to, if you have Mr. Cooper's opinion, if you don't, you can ask Mr. Jameson or Mr. Cooper, and they'll forward it to you again. But the last line of a case here says that a local government's failure to opt into the Jackson Law operates as a de facto approval of the proposed landfill, permitting companies to seek approval directly from the state. So again, it's a good legal memorandum, and those are questions that I tried to ask. I thought some of you guys may have. So again, I hope that this was helpful and you got some information that you can make the best decision that you can on Tuesday night. So thanks for being here. Thank you very much.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information about this and other programs, visit nashville.gov.